Good evening. If everyone could find a seat, we'd like to get started. I think I'll do this from down here rather than upset this august panel. I'm Matthew Diller, and I have the privilege of being the chair of the City Bar's Task Force on the Independence of Lawyers and Judges. Can you hear me? Is the mic working? Okay. I have the honor of being the chair of the City Bar's Task Force on the Independence of Lawyers and Judges, and I just wanted to say a word at the outset, and then I will pass the microphone on to my colleague, Peter Fox. This program is really offered in observance of the International Day of the Endangered Lawyer, which is a program started about 15 years ago by a coalition of bar groups and human rights organizations around the world. It's the actual Day of the Endangered Lawyer is January 24th, and it marks the date on which 4 labor lawyers were killed in Madrid following in the turmoil following the end of the Franco regime. And really, the purpose of the day is to call attention to the fact that lawyers around the world are so often targeted for the work that they do, and that autocrats understand that lawyers are a threat to them, that lawyers are a channel and vehicle for dissent, that lawyers speak up for rights, then they speak up to defend the rights of disfavored groups, and that lawyers have an allegiance to the law. And unfortunately, that also makes lawyers vulnerable and subject to persecution. And so each year, the coalition behind the International Day of the Endangered Lawyer designates a particular country to call attention to the circumstances of lawyers in that country. And past countries have included things like Belarus, Afghanistan, China, Iran. You can imagine the list of countries in that group. This year, in 2026, the coalition has designated the United States as the country to really focus on. And it really is both shocking on the one hand, and on the other hand, fully justified. It's really a recognition of the threat and the punishment that has been meted out to lawyers over the past year here in the United States. And so I want to mention one or two more things. One is I want to draw your attention to a new group that is being formed called the Endangered Lawyers Data Coalition, which has been established and is the process of being established to collect and publish information about attacks on lawyers across the globe. And a number of the founders are here if you want more information. So please raise your hand, Willie and colleagues. There you are. So anyone wants more information on the coalition, please reach out after the program. The other thing I wanted to call your attention to is that the Bar Association of the City of New York is also observing the Day of the Endangered Lawyer through a series of videos which launched today. And so please look for them on the web, and if you see them, repost them and spread the word. And the videos will really focus on highlighting aspects of the attack on lawyers here in the United States. The initial video was filmed by our colleague Susan Coleman, who is now chair of the City Bar's Task Force on the Rule of Law, which does fantastic work. And the video is great, so I commend that to all of you. And then finally, just a note on tonight's program, that while it's true and obvious to all of us that lawyers in the private sector here in the United States have been under attack and under threat for the past year, no group of lawyers has been under more threat than the lawyers who are public servants at the Department of Justice. And so tonight's program really focuses on the attack on the independence of lawyers in the Department of Justice, a subject that's of preeminent concern to those of us who savor and cherish American democracy. So without further ado, I'm going to turn the program over to Peter Fox, my colleague on the task force, who's taken the lead in organizing tonight's program. Thank you.
Thank you very much, Matthew. And in the absence of a podium, I'm just going to make these remarks choir style, if that's all right. As Matthew alluded to, it's fair to say that the Department of Justice is in crisis. After, at the very least, decades as perhaps the preeminent governmental legal department in the world, the DOJ's reputation for impartiality, integrity, and professional excellence is in tatters. Since the inauguration of President Trump 1 year ago today, numerous accomplished lawyers have been fired or forced to resign from DOJ, seemingly for no reason at all other than that they worked impartially and with integrity on matters disfavored by the president. Others have met the same fate for refusing to subordinate their professional judgment and ethical obligations to improper political directives, including in connection with what used to be unthinkable in this country: to look the other way from potential crimes committed by political allies of the administration, and to target the president's personal and political enemies. What this state of affairs means from the legal ethics and professional conduct perspective is the subject of tonight's panel. What are remaining DOJ lawyers to do when faced with legally questionable directives from DOJ leadership? What role does our state-administered attorney licensing and regulation process have in policing violations of law and professional conduct by DOJ appointees and employees? How about our court controls over attorney conduct? These questions are not just hypothetical. Yesterday, it was reported that the DOJ intends to promulgate a rule restricting individuals' lawyers' discretion to recuse themselves from departmental matters, a step in tension, if not outright conflict, with rules of professional conduct requiring recusal or withdrawal in cases of conflict or other circumstances. With us tonight is an outstanding panel of experts with firsthand knowledge of these types of issues. Our moderator is Emily Bazelon, senior research scholar at Yale Law School and a staff writer at the New York Times Magazine. Many of you may know Emily from her outstanding long-form piece on the DOJ published in November with Rachel Posen, The Unraveling of the Justice Department. We also have Mary L. Dorman, senior counsel at the Washington Litigation Group. Mary is a former federal prosecutor who, after leaving DOJ for reasons related to her pre-Trump work, now represents former DOJ employees on employment matters. We have Bruce Green, the Lewis Stein Chair of Law and Director of the Stein Center at Fordham Law School. Bruce is a scholar in the field of legal ethics and has long focused on the particularly complex ethical issues arising from government legal work. With us tonight is also Troy L.T. Edwards, former Deputy Chief of National Security at the United States Attorney's Office for the Eastern District of Virginia. LT recently left DOJ after the much publicized turmoil in EDVA. We have Sonia Mittal, former senior counsel to the Capitol Siege Section in the United States Attorney's Office for the District of Columbia. A political scientist as well as a lawyer, Sonia is a clinical lecturer in law at Yale Law School, where she just, within the last hour, wrapped a class on the rule of law, taught virtually, of course. And finally, we have Joseph Terrell. Joe is the former director of the Department of Justice, Department of Ethics Office, and senior ethics counsel for federal employee ethics at the Department of Justice. In that role, Joe was responsible for the development and oversight of ethics programs for over 115,000 federal employees.
Sorry.
And with that, I'll cede the floor to Emily.
Thank you so much, both to Matthew and Peter for hosting this event, to all of you for coming and giving the gift of your time. I am a graduate of law school, but I've never practiced law. And since I have a father and two sisters who do, I'm always very careful not to present myself as a real lawyer like probably almost all of you. I do have a strong sense, though, of the code of the legal profession and all of the rules and norms that you abide by and that people on this in this event with me have taken so seriously and really embody. And the idea for this piece that I co-wrote with Rachel Poser, who is here with her dad, which is great. Rachel and I were just really interested in what it would feel like to be in this transformed Justice Department in which the separation between the White House and DOJ, especially in terms of individual criminal investigations and prosecutions, has really been wiped away. And that is a kind of statement that President Trump has made very clearly and out loud, that Attorney General Pam Bondi has really furthered. And so we wanted to know what that felt like and looked like from the inside. And I just wanted to start with asking Joe about his experience of leaving as an ethics lawyer, kind of confronting this new reality. And then I'll bring in other people and feel free to kind of jump in too. Don't feel like you have to wait for me to ask.
So, the direct experience was I was sitting at home on a day off that I'd taken in the middle of July, and I got an email from an HR attorney in my personal email inbox, which is unusual because you're only supposed to do government business using government email. And my immediate response is, this must be a scam or a spam or something like that. And then following that up with talking to my boss, who was unaware of what was going on until about a half an hour later when he called me back and says, yeah, it looks like the Attorney General has fired you. But going back further than that, and you'll cut me off when I go to going back further than that, for those of you that don't know, because of my role as a senior ethics official for the Department of Justice, I advise senior leadership, including political leadership, on their day-to-day ethics conflicts, et cetera, which included Special Prosecutor Jack Smith. And in the fall of 2024, he asked me a series of questions about accepting pro bono legal support. I answered those questions as it was my job to do, and then joked with my boss at the time, this is probably going to get me fired. And we had a good chuckle about that. And then 6 months into the new administration, I thought maybe it wasn't going to get me fired, but clearly I was wrong. I think the reason why you fire the senior ethics attorney at the Department of Justice is exactly what everyone in this room is thinking, because you want to weaken the ethics process within the Department of Justice, right? It's more than just the fact that I did work for Jack Smith. It's we want no one to follow the rules. We don't want anyone to tell us that we're doing it wrong. So let's start at the top and work our way down if we have to.
Sonia, I know that you left early on and was connected to January 6th work, and I wonder if you could talk a little bit about that. That's been a whole group of people who've left because of the cases they work on.
That's true. I did leave. I resigned in my case just prior to the change of administration. And prior to that time, I had served as an assistant United States attorney and the senior counsel to the Capitol Siege Section, which was the section of the Department of Justice that handled approximately 1,600 cases arising from the events of January 6th. And just to give you a little bit of a sense of the background here, nearly 1,300 individuals were convicted. Nearly 261 trials were heard by juries and judges, and there were 2 acquittals, full acquittals in those cases.
I was one of those.
And I was the other one.
So maybe that's not the best way to start.
What I would say, though, is instead of spending a bit of time talking about the circumstances of my resignation, I wanted to say one word about why I joined the department. I joined the department because for me, like for many people around the world, the department served as a beacon of justice. I grew up in a family whose roots lied in countries where the rule of law operates very differently, where ordinary rules are often disobeyed, where bribes are normal, where courts don't work, where justice is delayed and denied. And for me, it was the honor of my lifetime to serve in a department where, notwithstanding the many serious challenges our criminal justice system has, was one that represented, at least for me, a model where justice was possible. And so I guess that's a kind of quick answer to your question.
That's a good way to start. LT, can you jump in and talk a little bit about, if you want to, about why you decided to leave, but also while you were there, how the culture of the department was changing?
Yes. I'll talk about why I left, and then I'll push back on the second part just a little bit. So I think the best way to talk about why I left is to do it through the lens of my 3 children. So I have 3 sons, 6, 4, and 1, and my wife and I joke that they're all born around national emergencies. So the first one is born right before the pandemic. The second was born in March of 2021, when I was part of one of the greatest teams I've ever been a part of, touring the country to find oath keepers and arrest and cooperate them. And my third son was born when 2 Navy SEALs died in the course of an interdiction in the Arabian Sea, stopping weapons smugglers from Iran. And they, I think, enjoyed having a father who was a prosecutor because they got to tell their friends their dad fought bad guys. And of course, they came to work one day and saw me sit at a computer, and they asked what I was doing. I said I was working, and they said, "No, you fight bad guys." And of course, my soul then left my body, and it was all a sham. And then, and so sometimes one of them would say the word cooperator when he was much too young to say that word. And my second son would sometimes get on a conference call with the Bureau, and my friends from the FBI would say, "Who are the Houthis?" And at the time, I think 2.5-year-old would say, "They're bad guys." And so I loved that work, and I loved bringing my family with me to do that work. Okay, now go to the inauguration in 2025, and the administration, the president, pardons a number of everyone, nearly everyone, from January 6th. And this is the second part of 3 steps toward why I resigned. I had to explain to my children that the president was someone who just let a bunch of folks, bad guys, of course we all know it's more complicated than that, but folks who had been convicted, go. How do you explain that to a 3-year-old and a 5-year-old? And my wife and I tried our best to talk to them about that, and then I stayed because it wasn't impacting what I would do on a daily basis, which was to try to fight for justice with the teams that I had the honor of being a part of. Now fast forward to September of 2025, and I'm sitting in an indictment return hearing. I'm sure many of you know, if not all of you know, that when an indictment is issued by a grand jury, there is a public court process in which the grand jury returns that indictment through a magistrate judge. And I'm having an out-of-body experience because I'm sitting inside a courtroom, not on the government side, but in the public side, waiting to see if an indictment would be issued like the press had been reporting for a week or two on my father-in-law, James Comey. And the magistrate judge reads his name, and it became obvious to me in that moment that this was no longer the department that I signed up to serve, because, as is publicly reported, the president had issued a declaration and an order to his Department of Justice, and that justice system executed on that order. And so I stayed that night. I packed my office, and I left at about 10 p.m. and proceeded to explain to my children that the president wanted their grandfather, Pop, to go to prison, and that their father no longer was a prosecutor. And so this was not a system that I could stay a part of anymore, which I'm sure we'll talk more about. As I explained to my 6-year-old, I didn't want to say the word quit because we've tried so hard to teach our sons not to quit anything. And so my 6-year-old got it pretty quickly. He goes, "So President Trump fired Pop?" I said, yes, he did. He says, President Trump fired Aunt Maureen. And I said, yes, he did. He goes, you fired yourself. Yes, that's exactly what I did. Good, I'm glad you get it. And then he proceeded to brag to his friends in first grade that, well, my dad fired himself. None of them understood what he was saying, but I was honored that he felt that way. And so now here I am. The second part of your question, my answer will be a little shorter. The pushback I have is, your question was the culture changing, the department and the institution I was a part of. I'm not sure that the culture of the institution is changing. I think the people who lead it are trying to do that, and I don't think they will succeed. And they can shout at it all they want, but I don't think they'll succeed. I think the way I'll try to answer your question is, how are those people changing some of the things we did on a day-to-day basis? One very important way was directing prosecutions, right? When we would sit in a conference room across the country, we had the opportunity to be Michelin star chefs. People across the Department of Justice had the chance to focus on the higher level thinking. How can we deal with this nuanced defense? Is this the right thing to do? We could do that because we had the foundation underneath us, knowing that the easy stuff, right? The facts we're receiving were true. The instructions we were receiving from our bosses were good ones. There's no agendas around the room. That conference room had the space to focus, be the bear, right? We got to focus on the presentation and put out a plate that looked beautiful. We tried. We failed sometimes, but we tried. The way that they were trying to change that culture was, now we have to question whether or not the meat is rank that's coming to the kitchen. And we have to wonder if the folks who are giving us the ingredients are giving us good ingredients, bad ingredients, are cheating the people they're buying those ingredients from. That just robbed us of the space to think in those upper echelon, nuanced spaces. We were now down thinking, boy, why are they bringing this case to us? And I think that has a devastating effect on the department.
I like that metaphor. I bet we'll end up coming back to it. I wanted to ask Bruce and Mary. So, the attempted so far unsuccessful effort to indict or prosecute Comey, and then Letitia James, and now there's obviously a list of people who the president has called for criminal investigations, and lo and behold, they're targets. So this is seems like a clear misuse of prosecutorial power, not what we have had in mind since Watergate, right? Which presidents from Nixon until now did their best to stay far away from. At the same time, it is true that presidents direct policy for the Justice Department. So Bruce, when you try to think about this and explain maybe to your students or to the public how these lines should work, how do you do that? What are the norms here? What are the rules? And do we need new rules going forward at some point if we are so lucky to be able to enact them?
Well, of course, my classes go on endlessly, and but there's and President Obama actually wrote an article about the president and criminal justice, and there's a policy is general. Let's do more drug cases. Let's not do white collar cases, and it doesn't involve targeting any particular individual. Whereas what's going on now is, sending, I guess they're not called tweets anymore, but whatever, stuff on social media about, like, this is who ought to be indicted. So those aren't judgments about policy. They're judgments about weaponizing the criminal justice power against particular individuals. And I think anybody can get it pretty much because, we're going back to the idea of an enemies list, and that's not what you're supposed to use the criminal justice power for. I will say in my classes, we use the phrase seeking justice a lot. And, as a prosecutor, that's what I was told we were supposed to do. And people can have different judgments. There's a lot of discretion involved. And there's a lot of judgments where individual prosecutors can come out differently. But the idea is to make those judgments based on the law and the facts and on the legitimate considerations that are reflected in traditional Justice Department policy and not on self-interest and arbitrary considerations. And so, if you're saying go after some particular individual, and the person who's saying that obviously has partisan political motives and is not moved at all by the evidence because they haven't done the investigation, I mean, that's turning everything that you learn in the Justice Department on its head, I think.
Mary, I want to ask you to pick up there, but I also wonder if you could talk a little bit about what you're seeing in the private bar. You're part of this really interesting group, the Washington Litigation Group, which has formed in a lot of ways to try to respond to some of these changes and defend clients who have been caught up in them. And I wonder if you could talk about how this looks from the vantage point of your clients, and then maybe also why you and your colleagues felt like it was necessary. Was there a kind of lack of representation, especially from big firms, that has made this work particularly important?
Sure. So just sort of starting at the end, yes,
Yeah.
I think that is exactly what we saw, and I'm so fortunate. So I guess I'll give just a tiny little bit of background on me. I was, like Joe, I was fired. I was fired on January 27th of 2025, so we were among the first. It was very unceremonious, Joe, just like your experience. And after that, I experienced, of course, just an immense amount of grief about both what I had seen at the time as the end of sort of what I had wanted to be the centerpiece of my career as an attorney, which was public service. And public service at the DOJ, as Sonia has so eloquently described it, this beacon. And so, and then of course the grief of over the days and weeks that followed, understanding that the job that I had had at the DOJ of doing justice impartially, complete in line with citizens' constitutional rights didn't exist in the same way anymore. And then it went from bad to worse with the executive orders targeting law firms like Covington that had been advising Jack Smith and others, where there was now an intimidation in the private sector that has done so much exceptional pro bono work that's government facing for decades throughout all administrations. And so I was very, very fortunate to find this group of retired law partners who helped to found the Washington Litigation Group to fill that gap. And it's been so wonderful and really heartening to be able to continue public service, I think, in my view, in the great tradition of sort of the nonpartisan DOJ sensibility in this new arena. So yes, there is a great need for that work and what we're doing for our clients and for the firm. I think, and picking up a little bit on what Bruce was describing, I think what's so hard, so you hear from this current administration, this invocation of Article 2, right? That's the part of the Constitution that lays out the entirety of the executive power. By the way, it also gives power to Congress, but it is the executive power. And what those invocations completely miss is the entire rest of the Constitution, and particularly the Bill of Rights and the rights that citizens have in criminal investigations and prosecutions, not to be retaliated against for First Amendment or political reasons, not to have their due process rights violated, to be prosecuted vindictively or for personal reasons of the person in power. And so what's very difficult is sort of starting back at those basics. You're fighting this battle in the courts that we haven't fought for a long time, because everyone understood that DOJ's independence was so important to preserving those constitutional rights and the Bill of Rights that citizens have, and not allowing them to be trampled on by government overreach.
I wonder, and I'm not exactly sure who to start with, but maybe Sonia, I'll try starting with you. I wonder what you think about the response of the legal profession to all these changes. So obviously that's a big sprawling question. There are state bar associations, there are big firms, there are smaller firms, there's the whole part of it. I wonder, Sonia, what you see that has been kind of hopeful to you about the response in the legal profession and what you see as more troubling. And maybe everyone else could think about that question too for a second. And I'm sorry for putting you on the spot first.
No, thank you. It's sadly a question I've thought a great deal about.
I thought maybe.
Well, so I think the answer to that question depends on how you define it. And for me, the question of what is happening at DOJ implicates both the department that I love very much, its expertise, its capacity, its credibility. But as a political scientist, I say to myself, it implicates a whole lot more than that. It implicates what I've called the capture of law enforcement institutions, which is a phenomenon that I and many, many other scholars of democratic erosion and failure have studied in a lot of different countries. It's a well-worn path. And it's hard for me to come to a conclusion that we are not somewhere on that path right now. So given that I hold that view, I think that sort of colors how I view the response of the entire legal community. And this is to say, you know, I have very, very dear friends who I respect in all parts of the legal community. But just given how I see it, I think that the rule of law challenges that we see in the Department of Justice affect and implicate the work, the practice, and the obligations of every single lawyer in the United States, and irrespective of one's practice. There's a really prominent, it was published in the New York Times, two of the leading theorists of democratic failure, Stephen Levitsky and Daniel Ziblatt, wrote an op-ed saying, how do you know when you've lost your democracy? And they proposed a really simple metric. They said, if you think twice about writing something online, or if you think twice about whether you should say something the way you'd like to say it, that's a red flag. And I think if we all ask ourselves these questions as lawyers, I think we will all, or many of us will conclude that we've gone through that exercise, that you've thought a little bit about how we might present our backgrounds on LinkedIn, or what it would be like to take a particular project to a partner in a law firm, or what the implications could be of doing that. And under that view, I think this is relevant to the practice of every single attorney in the United States. And within that context, then, I think what is hopeful? What is hopeful is that I think this is becoming increasingly well known and quickly. Even though the changes over the past year have been abrupt, I think the response has also been abrupt. And we all are sitting here together and having this conversation. This is a luxury that is not afforded in many of the countries that have experienced some of these challenges. So I'm optimistic about that. On the other hand, what do I wish? I think the changes over the past year have moved very quickly, and I think the reality of the challenges of achieving collective action in any community, but particularly in communities as diverse as our legal profession, are challenging. And I think we need to make, I actually brought a quote of one of your esteemed colleagues, Masha Gessen, who is I think a really extraordinary voice on sort of the psychology of this moment. He writes, Masha writes, now is the time to focus on the similarities and try to learn from the other ways countries have cracked down on protest, eviscerated electoral systems, and limited their media freedom. The only way to keep the space from imploding is to fill it by propping up the walls, to claim all of the room that there still is for speaking, writing, publishing, printing, and voting. So to me, That is both the imperative, and I draw a lot of hope from that, but it's a tall order.
Joe, do you want to bring that into the legal profession and the responsibilities that lawyers have ethically and otherwise to be, Sonia's talking about a lot of quiet trimming of sails, but what should be happening out loud?
So I dealt with, obviously, a lot of attorneys within the department in the last 6 months before I left, who were dealing with complex issues and trying to decide what they should do next with their career. You know, if they were being asked to do things that they didn't agree with or that they thought were inappropriate. I've been asked since then questions about the law firms that did or did not make deals with the administration. Is that appropriate? Is that inappropriate? I understand that law firms are businesses and that you sometimes have to look at the bottom line and go, all right, well, maybe we need to take this step so that we can better serve our customers elsewhere. I'm not saying that's good or bad or otherwise in this particular situation. But federal employees, and in particular the legal profession, takes an oath to support and defend the Constitution of the United States. So whether or not you're looking at the bottom line or whether or not you're saying, I don't really want to lose my job, I'm 2 years away from retirement, that can't be the primary consideration when you're taking an oath that, in my view, always superseded personal priorities. And that's what I come back to that makes me so, I'll disagree with Troy and say I think the culture is changing very slowly, not as much as we might think if we look at the news as cynically as some about what's going on, but it is changing because people are making that choice to not do or to do something that's inappropriate, and I'll even go so far as to say illegal or unconstitutional because they don't want to lose their job. Now, you can say that that's because someone else is making them have to do that decision, right? Don't go walking late at night because you might get mugged. You know, let's blame the mugger. And that's what I would kind of want to come back to. These people are getting mugged, and we need to blame the administration for putting folks in that position, whether it's a law firm or federal employees. But we've also got to raise expectations and say, you've got to hold the line. You've sworn an oath to support and defend as an attorney or as a federal employee, and you can't go beyond that.
Bruce and LT, can I bring you in here a little bit to talk about the role of state bar associations? Should they be policing and doing more than they're doing? You know, there have been some pretty flagrant examples of Justice Department attorneys doing things publicly. I'm thinking right now of Lindsay Halligan and this face-off she's in with the district court and sort of the Fourth Circuit in the Eastern District of Virginia. Have state bar associations done enough? Are they getting the kinds of complaints they can act on?
Well, I'm going to say no, so if you want to say yes, you can start.
I think we might be in agreement.
So first of all, we're not really talking about state bars in a lot of states. We're talking about the disciplinary authority in New York. It's under the auspices of the state courts. And so what you're really saying is, should state courts be reining in federal prosecutors who were being, criticized by the judges and for false statements or for other things? And if I were a state court, I would not want to get into this mess. My view is that it's a federal court's problem. Federal courts have authority to discipline the lawyers who appear before them, both the judges who are overseeing particular litigation and the district courts as institutions have disciplinary authority. So I think if there's any place where it should take place, it's there. But I also think that we should not really, I think in prior administrations, the disciplinary authority was weaponized a little bit, or there was an attempt to weaponize it. And so there's just like a flurry of disciplinary complaints against federal prosecutors now, and there were, in the prior administration, from the right. And there were, have been, federal prosecutors, or at least the DOJ people like Jeffrey Clark, who I do think deserve what they have gotten. But I think that it's really, a lot of it is political, and you can understand why the Florida bar, the DC bar, or other disciplinary authorities have not wanted to touch this stuff. So that's sort of my reaction. I don't know, what do you think?
I don't have much to add. One piece I'll say is a lot of folks talk about the independence of the Department of Justice being just a norm, needs to be protected. I think it's a lot more than that. The independence of the department, we can have an entire discussion about how it stems from the history of this department, right, all the way to 1870 when we constructed the department. But beyond that, just the principles of where this norm, this independence comes from. There are constitutional principles, there are statutory frameworks around those ethical principles. There are rules and regulations, policies, and then norms. I see norms almost as the last part of that tiered structure of where this independence comes from. So to answer your question, yes, bodies that are responsible for enforcing some of those sources of this independence ought to step up. And then two bodies that you asked in an original question of who is helpful, who we're happy with, that we haven't mentioned yet, two teams. One, the judiciary. The federal judiciary is really living up to their role in our constitutional structure. And it's really a great thing to see. And the second is an unforced error a bit by the administration is the government team in exile. There are a number of folks across the country that were passionate about doing the work of the Department of Justice. And I have over and over again seen those folks now team together on the other side of the V or in speaking out. And it's as if the Knicks fired Jalen Brunson and pissed off some of their other teammates, and these folks went to the Nets, right? It's a really dumb move for the Knicks. They shouldn't do that, and they wouldn't. But this administration has done that, and I'm proud to see a number of folks who were part of the department step up and call it out.
Glad that we've gotten both the Bear and the NBA into the conversation. Mary, can you pick up there? Can you talk a little bit about what's happening behind the scenes? Different lawyers coming out of DOJ or having been there really wanting to work on these rule of law issues. Is there like a network? Are you all talking to each other? I only see this as like calling people asking for help understanding things or interviews, but how are you all networking and trying to create a kind of, nonpartisan rule of law based response to these challenges?
Absolutely. So, there are so many people who are leaving DOJ for any number of reasons right now who were not finished with their commitment to nonpartisan public service and want to continue doing that. And that is such a wonderful thing for groups like the Washington Litigation Group. And I think, of course, for the country as a whole. But it is challenging. It is really, really challenging to create all of the structures that are needed in order to collaborate and work effectively to mount really, exceptionally effective challenges in the federal courts to the immense volume. I do not need to tell anyone in this room that every single week, maybe 2 to 3 times a week, there is a major, constitutional or other, legal issue that needs to be addressed, often through litigation, not always. And I also don't need to tell you all that litigation is very resource intensive and time consuming. So I'm trying to think of a good metaphor. LT, can you lend me one of yours for what we're trying to do? Perhaps, building the plane laying down the track as the train is coming through. And so, yes, it's happening, and there's the network and the will and the desire is there. But it really is, an immense effort that I would encourage, anyone who has interest in contributing to in whatever way you can to do.
As a journalist, I've been very impressed with various small law firms, small shops around the country, really devoting themselves to this work and stepping in where some of the big firms seem afraid to do so. Can we talk a little bit about the act of leaving and speaking out? Obviously there are these different routes. Some people have resigned and made a statement, written a letter. Some people have waited to get fired. Other people have quietly walked away. And there obviously are lots of different considerations for the different kind of pose one strikes in that moment of how out in front to be, how much to speak up. At this point, is it important for more people to speak up? I'm sort of influenced by Jerome Powell's video last week. Now, obviously, like none of us are Jerome Powell at all, but he did have a huge impact by being extremely straightforward and speaking to the camera in this like very modern form of communication, which I can't imagine he really felt like came naturally to him. And it just made me wonder, and, are we at a moment where that's the way people need to leave the department or need to make an impact? And, or do you think like, well, that's not realistic and most people obviously are going to quietly resign so that they can find another job?
I mean, exactly, Emily, what you just said. I think I could not fault anyone for making the decision that is in the best interest of themselves and their family right now. It is not any individual's responsibility to by themselves, put themselves into danger in an environment where they may not even feel that they can rely on, the normal supports that are in place. And I do hope that groups like my firm and others are offering some more support to encourage people to feel more comfortable taking a stand. I mean, I think another thing that I know that many people think about is not just themselves and their personal safety and what it means and for their employment, what it means to speak out, but also what it means for their cases that are still ongoing in the Department of Justice, for the national security, the concern that many devoted public servants have of if, foreign adversaries understand how dire the situation is, that can contribute to a lack of safety as well. And those are incredibly, incredibly difficult decisions to make. I do think, though, Emily, that if someone feels that they can speak out, I do think it's important for there to be sunlight and for the country to know what is going on.
Does anyone else want to jump in on that one?
Can I just ask our ethicist, are there confidentiality concerns that might limit people even who do want to speak out?
I have tried to adhere to my confidentiality concerns, but keep in mind my clients, the United States government, not an individual, so our confidentiality issues are sort of interpreted a little differently. I'm also treating my oath to the Constitution, I think, supersedes, in some cases, my oath to the bar and the bar rules. I'm not saying I'm ignoring the bar rules. Please don't misinterpret that. Thank you. But I think that has to come first in some ways. But yeah, you have to be cautious in talking about confidential things. But I didn't have any clients. My client, even when you may read about me having advised the Attorney General was never my client. The United States was my client. So she did not have an expectation of confidentiality in anything that she told me. And I made that clear not only to AG Bondi, but also to AG Garland, as well as to numerous other officials. Hey, I'm glad that you're talking to me. We're going to get to the right answer. By the way, there's no attorney-client privilege in anything that we're going to discuss. So that should hopefully give those that aren't dealing with litigation directly some ability to talk about what happened to them personally in particular.
Bruce, do you want to jump in about how you see
No, I mean, I'd like the answer to be that notwithstanding the fact that you're all lawyers, when you leave the government, you could talk about not, grand jury secret material and classified information, but about your experience and with regard to decision-making. I think there are whistleblower laws that to some degree will allow people to talk, and I think personally think those trump confidentiality. But there's also a tradition. People leave office and have written books and things. And I think, I think there's sort of an informal expectation that's not adequately reflected in the rules of professional conduct that people can talk about their government service. So I was just wondering, like, you know, I wasn't knowing about you particularly, but what kind of advice you might give to a former DOJ lawyer. And I'm hopeful that the answer is that you do have more leeway than, you know, private lawyers would have to talk about their professional work.
Yeah, absolutely. I mean, because of the difference in who your client is and whistleblower laws, I think you definitely have much more ability to speak about things not related to the litigation that you worked on personally, but things that you experienced in the office, in your environment. Particularly, I think several of us are engaged in litigation with the department about being fired. So, yeah, I've got to talk to the court about that, as well as I think to the public, as well as to others, to encourage them to step forward. So,
I just wanted to add a quick note to commend the courage of my colleagues in the department who have chosen to speak out. I mean, as is publicly reported now by Emily, you and many others, we all know that many prosecutors, particularly those who worked on sensitive cases that were disfavored by the current administration, have experienced a wide variety of threats. They have experienced difficulty securing employment. They have experienced difficulty securing representation. And all of these things have effects on individuals and families and communities. And what I find admirable is that in the face of it, in the knowledge of it, with the knowledge of it, they continue.
LT, we were talking a little bit before we started the panel about the kind of habit that I think a lot of lawyers have, and especially in government service, that I think you put it, scurry away from reporters. You're speaking through the documents you file and the arguments you make in court. You're not supposed to be speaking through the press. And I have talked to so many people, and I know Rachel did too, who have said, like, basically, I can't believe I'm on the phone with you. I spent all these years in government service avoiding reporters, and I'm having to just shed this whole sense of well-earned, I don't know if mistrust is the right word, but resistance to using this vehicle. I wonder, LT, if you can talk about that a little bit and how you think about it now.
Yeah, I don't think I ever ran from you in a courtroom.
No, I didn't give you a chance, or
but
you
some.
would have, I'm sure.
Yeah, I think I wanted to give voice to that pressure, right? So that way you folks who have not been part of the department can appreciate that you want your federal prosecutors to be really hesitant here to do what, and I'll get to this in a second, should be done right now, right? The people who become federal prosecutors should not be the folks who are sprinting to the reporters in the hallway. Some do, but most don't. And you want people who run away from that and speak only through the filings they make in a courtroom and through the arguments they have at the lectern when defense counsel have the chance to respond to them. That's the system. That's how it should work. Okay. Now, where are we today? That's not going to work, right? I think we should be graceful to that ethos, appreciate it exists, but continue to speak to those folks who step out and tell them, when you leave, you are, I hate to be the metaphor guy now, I guess I'm realizing this, you are a bit, right? The folks who are in are the current carbon monoxide detectors in the department. If you don't resign, if you don't quit when your red line is crossed, if you don't speak out in some way that you are comfortable with your safety and your financial security, we won't know about the carbon monoxide that's poisoning parts of our department. So folks who leave have to continue to be that detector. And the folks who have already left have to be outside the house shouting, there's carbon monoxide in the house, right? Because people who are in there who are new may not know, right? But think about the people who are in the department right now, learning that this is how the department runs. That should send a shudder through everyone sitting in this room. Mm-hmm. We have to shout into that house that there's carbon monoxide in there, and folks who leave have to be that detector. And that's just, unfortunately, the problem we're facing right now.
Yeah, I mean, it feels to me like working on these stories that it's a sign of internal breakdown, that so many people have left, that so many people feel obligated, kind of morally obligated to talk to us, that none of that is good, but given the situation we're in, it's also necessary. I want to, before I open up questions to the audience, which I'll do in a minute, I want to ask you about how you think about what a first-year law students should be making of all of this. Do we still urge the young people in the Depression to work for the Justice Department, to apply to the honors program? Do we say to them, like, hey, we're really not sure that you all are going to be able to rebuild this institution? Maybe you should go work for a state attorney general or a different part of the profession. How do you all grapple with that? I imagine that it would be very hard to give up on the department given all of your public service. At the same time, it seems to me like it is hard right now to quite see the way back. Joe, how do you think about this?
So the panel was talking earlier about this, and I think it represents the panel well, that nearly everybody on this panel came in through some sort of internship, fellowship, honors program. I was a presidential management fellow. I think several folks were honors attorneys. I think, unfortunately, most of those programs have been canceled in the last year, so that this question may in some way be moot for the next few groups. I've spoken to law school classes and told students, go into state government, go into local government, which is probably the path that most junior attorneys would have to take anyway to, kind of cut their teeth on the law and before they could apply for sort of mid-level positions at the department. I still believe in the United States. I still believe in the Department of Justice, despite my sort of more sour opinion on some things. Would I go back today? Yes. And people have asked me, well, what would you do if you were asked to do X, Y, and Z? I go, well, I get fired again. But that, I think, is the thing you have to tell folks. You have to go in now prepared to know where your lines are and to be prepared to say no, and then to be prepared to accept the consequences of that. And if you're not ready for that, then you probably, if you're not ready financially in your career, et cetera, then you need to go elsewhere before you can go back to hopefully a better department in the future.
Sonia, how do you think about this when you're looking at those bright-eyed 1Ls?
Yeah. Candidly, this past year teaching, I've had the chance to speak to a lot of students whose dream it was to join the Department of Justice. And I know what that feels like because that was my dream too. And those conversations have been extraordinarily difficult for me. And part of the reason for why, I think, is very much about what Joseph is saying. I probably have a somewhat more pessimistic view when it comes to law students. I think they're at the beginning of their careers, and when their careers will be long. And the two things that their careers will be long and their reputation matters more than almost anything else in this career. So to me, I tend to think that it's, we've been in kind of this posture for a little bit more than a year. We have plenty of time to come, and we don't know how far the situation may slide for the worse, but also potentially for the better. And it's very hard for someone who's a first year to make any sort of prediction about that. And secondarily, I think it's just unrealistic to think that any lawyer who enters the department is not going to be affected by either the spoken dictates of the directive that they hear directly or by the indirect changes in the operation of the department as a whole. And I have many, many colleagues in the department who I think are the finest prosecutors I know. And they too are also being affected by those very dynamics. So where I kind of come out is to say, I take no position. In the end, everybody is responsible. That's the point of being a prosecutor. You are responsible. for your decisions. But I would say that for law students, their careers are long, and that there could be a benefit to working with people like Mary, with people like LT, people like Joseph, and getting the best litigation training you can with them. And there could soon come a day where one could return to the Department of Justice without being potentially put into positions that are very, very difficult for first-year students to confront.
Mary, how do you think about all of this and the rebuilding part?
Yeah, well, first of all, yes, tell them all to apply to the Washington Litigation Group or to go to a private law firm and say, I want to do this work. I want to do the mission-driven pro bono work. So, I mean, and I think I hope everyone in here would agree with me that I think the advice I would generally give to somebody for their first law job is, it's going to be kind of like an apprenticeship. You learned a lot of stuff in law school. You're going to learn a lot more. So go where you can practice with people you deeply admire and respect and who can be mentors. If you can find that in the federal government right now, then find that person and stick with them. But I wouldn't just assume that.
And hope they don't leave.
Right. That's right. But I am totally optimistic about rebuilding the Department of Justice in some time. I think what LT described as sort of the team of exiles. There's so many people outside of the department now who, we're not going to forget how it's supposed to work and how it did work for a long time. And there are a lot of people still in the department who know the way that this is supposed to work and how the institution should be run. So, I am optimistic. This is, every time a metaphor comes to mind, I just think of LTs now. But we are in a marathon, not a sprint, and that refers to this period that we are in right now, and it will also refer to equally describe the period of when there is an opportunity to bring the Department of Justice back to its independence.
So, Bruce, if and when that day happens, does the department need more rules as opposed to norms? Are there additional safeguards that could be put into place? Do we need another post-Watergate moment?
I would, hopefully there's a different Congress also, and I would say that Congress should codify the things that were the norms that were instituted by Attorney General Levy and continued pretty much until now, that create a separation between the political part of the White House and the department, that insulate individual prosecutors from partisan political decision-making. I think it's more of a challenge to do it now, given the Trump against U.S. case and the idea that the Supreme Court has about unitary executive. But I do think that it's important to depoliticize the Justice Department to the extent possible. In the past, I just do want to say we have the least, as a structural matter, the least independent prosecutors of any place in the world, any democracy in the world. In other countries, the prosecutorial arm is insulated from the political arm. What preserved independence was the culture and the norms and the DOJ manual. And obviously, we've learned that all that can be swept aside. And so I do think we can't rely anymore only on tradition and culture and norms, and we have to codify that in some way to the extent that you can.
LT, can I give you the last word on this part, and then we'll take some questions. Think of questions.
Yes. I'll be dramatic for a second. That night when the cow in Chicago kicked the lantern over and burnt the city down. Within a year, that city had the start of a skyline again. And that's because a worldwide search for architects ensued. And they all flocked to that city. And I hate to say this, in New York City, it developed one of the greatest cities in the country and in the world. That's what we're seeing right now. We're in the early stages. The department's burning. It just is. I don't think there's a way to say it differently. But man, there are a lot of architects across this country, smart architects, who are getting together and trying to answer that question. And a significant part of that is you folks and 1Ls. And I say 1Ls because 3 years from now, they will apply to the DOJ Honors Program. And they will become part of that new scaffolding. And it's not a rebuild. I push back on that. If your house burned down and you had a squeaky staircase, you wouldn't put it back in, right? The department was imperfect. We all know it. We could have a whole panel on the imperfections that existed in that department, but it worked. And there were so many areas to improve it. This is a chance. Sonia's not going to be surprised by this. I'm the eternal optimist. This is a significant opportunity for our country to build a department, and we're going to do that.
LT, I just note that your analysis hinges on 3 years. Rather significantly.
I would love to take some questions. There is a mic over there, but also it's not that not that hard to say a question too. Yes.
I've been a civil rights activist for 60 years and then became a lawyer, civil rights, civil liberties lawyer. Government lawyers were so important to us. Two of my role models, when I was in Mississippi in 1966, I was told if I was arrested, call John Doerr. When I was head of the Civil Liberties Union, we were dealing with death penalty issues. I had James Comey come. John Doerr, James Comey spoke to our clients. They made a world of difference. I came tonight to thank all of you for facing clear and present danger, the democracy that we love. And I think this is wonderful. My challenge and my question, could you come to the communities, to our clients? They need to hear you. They think lawyers, other civil rights lawyers, are no good. Hearing your words, your passion, your generosity, even your humor, the people need to hear you. This is a wonderful forum, but get out in the communities. Organize, go. The people need to hear your voices so they have hope. Thank you.
That's more of a charge and imploring than a question. Thank you so much for that. Go ahead. I'm going to leave the picking to you. It's always hard.
I wonder if anyone on the panel is in a position to describe the kinds of young attorneys who are coming into the Department of Justice and the U.S. Attorney's Office these days within the last year. Because one of the things that terrifies me is when I see the recruitment efforts for ICE and for other law enforcement and the kinds of people who are responding to that call. And I fear that while you talk about rebuilding in the future, are the people who are going into the Department of Justice now, do they have any red lines?
Does anybody want to take that?
I don't have an answer for you. I didn't see outside the politicals, which I worked closely with in educating them on ethics, I didn't see a lot of hires by the time I was fired. I read recently that the department's claiming they've hired something like 3,400 attorneys, but that's really mostly folks that they've transferred from other federal agencies. It's not a true hire. I see advertisements on USA Jobs for positions, but you know, the government works slowly, you know, big shock there, right? We don't hire thousands of people overnight. and whole offices have been shut down. 2,300 people have been fired. 10% across the Department of Justice have resigned. I guess the good thing is that means there's probably not a lot of people coming in, but the people that are coming in, I would be concerned that a chunk of them are being recommended by people that don't have any red lines.
Hi there. Oh, this one's very sensitive. Hi, I'm Brett Parker. I'm the executive director here at the City Bar. Thanks, first of all, to all of you for being here, for speaking and sharing your thoughts. I have to hold this really far away.
Or just abandon it entirely.
All right, try. This is much better. So first of all, thanks to all of you for being here, for your time and for your sharing your thoughts. I really appreciate it. Thanks to the whole audience for coming here on a cold night. I really am inspired to see so many people here. So I have one suggestion and then one question. The suggestion is, for all of you who are here interested in this, tell one other person to get involved with the City Bar, to come to events, to join our committees, to do the work of fighting for our democracy. And so most of the people here are the choir, and we're preaching to the choir. I think we need to preach beyond the choir. To that point, to Emily, here's the question. Often we find that lawyers speak about the rule of law and all these issues with very high platitudes and very things that are sort of instinctive to us, but my teenage kids and young people, they don't get it. And maybe it's because we don't sell it the right way. Are there other ways we should be talking about these issues to help them to understand what is so instinctive to us and we learn through law school and practice, but is not sort of YouTube or social media friendly to the non-lawyers, and how do we break through the noise?
That's a great question. I mean, this is my my challenge I set for myself. I often think of myself as a translator, not just of jargon, but of a kind of set of values and rules and like a kind of tribal code that the legal profession has. And I think usually the things that resonate the most are individual stories. Giving an example of something that's very concrete that hopefully can translate into some way of really bringing home what's at stake. And the editor who Rachel and I worked with for the story is really good at making us explain to her what's at stake. And so when we were putting together this piece with all these different examples, Joe's story was there. There were lots of different people, and we were really trying to encourage them to give us concrete examples. Like, I was being asked to do this thing. I had this case. I wasn't going to be able to do what I thought was right, what the professional demands were in this particular circumstance. And I think that those kinds of stories can really break through. Sometimes you have to tell them a few times to people who aren't lawyers, who don't know all the things you know, to figure out what is hitting. So that's something I would recommend. And I think everybody up here has those skills and is figuring it out, but it is something that the profession as a whole would really benefit from more of.
Thank you. I'm Ben Spersky. I'm a law professor and therefore a little more wordy than I should be. I'm sorry. Someone said that people who are forced to leave or fired, it's not their responsibility to call out or address the problem fully. And I am sympathetic with the idea that going to the public is not their responsibility, but there are actors whose responsibility it is. So the Senate and Congress in general, I do think it's their responsibility. I differ with my friend Bruce Green. I do think it's state disciplinary authorities' responsibility, and I think it's lawyers within a jurisdiction where they're aware that these things are happening actually do have a responsibility to take action here. So I'm wondering for all of you, number one, whether you agree or disagree with me about those actors, and number two, what concrete steps could and should those actors take? I just to add one thing, I'm a torts professor. I actually am on the side of people who think affirmative duties to stop other people from doing bad things are not all around. I'm kind of conservative in that way. But these three actors I pointed to, they do actually have affirmative responsibilities to take action to stop this or to discipline it.
Who would like to take that?
Well, I can argue with you when we get back to school, so I don't think I should be taking that. But I will just say again, I think that the federal district courts have the primary responsibility for regulating federal prosecutors rather than kicking the can to the state courts and the state disciplinary authorities.
So I was hesitant to respond, lest this be viewed as a shameless plug, but consult with an attorney at the Washington Litigation Group or elsewhere. I think that is something that people can be doing and should be doing, is finding those pro bono services that exist to sort of figure out what for their individual case is a next step. I mean, I think the state bar question is really interesting. I mean, we don't have a federal licensing authority, and so it does seem to me that if you have a member of your bar as a state that isn't complying with your rules, that should be of interest to you. But I think something that's really important about what we're talking about here is that this isn't a mystery, or this isn't a secret. It's not a secret that so many things that are wrong are happening. And so that's where I think that there is, this is something that people are aware of. And I'm not, of course, these individual stories are really, really important, but I do think there's a critical mass that people understand that this is going on, and that really, individuals who want to take action, if they have questions about their ability to do so, I think should consult with an attorney. But I also think, just collectively, there are, you mentioned Congress, right? Like there are actors that have a role to play here that hasn't all quite played out yet.
This is, I hope, a fair question. And if it's not, I apologize and tell me it's not. But there was a German historian, Meinecke. He wrote a book called The German Catastrophe. And he basically came to the conclusion that it was a 1 in a million shot that Hitler came to power. And there are a lot of reasons to dismiss him. But when I looked at what's happening with Trump and with the legal profession, the first thing is I could see it happening a while ago. And yet the profession responded horribly. Whether it was Merrick Garland sticking his head in the sand, whether it's been the conduct of the New York County DA's office for 3 district attorneys, whether it was a clown in Atlanta who doesn't know how to run her office to not have a serious ethical problem, and I can go on. So why was the legal profession so incompetent in facing a threat to democracy, as it has been, and it has been pathetically bad? Is it a 1 in a million thing where all these horrible things happen, and who could have imagined it? Or was it a situation, when I practiced, for a while I worked with some radical lawyers, and none of them would be surprised at this. There's a story, it's a true story, I apologize for the language, but the language is important. There was a writer who got beaten up quite a bit in '68 in Chicago at the Democrat Convention, white. And when he was on a plane leaving, he was sitting next to an African-American gentleman, telling what happened, and the man looked at him and said, well, now you know what it's like to be for a week. Maybe you're learning what it's like to be a for a week, and why the hell didn't you know sooner?
I have a couple thoughts on that one. I mean, for the most part, I completely agree with you. This all has been in the works for quite some time. And I think that's really important for every American to understand, that it's not only been in the works for some time in the United States, it's been in the works for some time across the world. So we're now at the point where, leading, there are very sophisticated shops that monitor sort of indicators of democracy about, like executive overreach, electoral manipulation across like many, many, many countries. And the outlooks are poor. In particular, the Economist itself now grades the United States not as a full democracy, but as a flawed democracy along the lines of Poland. And so I think, to me, it's not a 1 in a million. And that requires us all to learn more about the situation, about connecting the different parts. We're talking about DOJ here. And DOJ could be, what's happening at DOJ could be viewed as one instance of a weakening of a check on executive power. But many of these institutes study hundreds of different checks on the weakening of executive power, whether it relates to military involvement or other things. And I think when you start to look at the picture across all of these indicators, you start to see a much clearer picture. And for me, that picture is a little bit sobering, because what it shows is that along a number of key indicators of executive overreach and electoral manipulation, the trend lines have been going down in the United States and around the world. And that is the reality that I think each of us as individuals, as lawyers, and as citizens have to confront. And it can be extremely uncomfortable to confront that. When you sit and watch the news, it can be extremely uncomfortable to think about what is happening on a day-to-day level and exactly what to do. You can push it out of your mind, but I encourage all of us as a starting point to begin to understand that this is not the reality of 3 years. This is the reality of much longer than that. And by coming to accept this discomfort as part of our regular lives as American citizens working for the country that we love, it's just an unusual and newish feeling for us. I think that's going to be required in order for us to be able to make structural change.
We have time for one more question.
Thank you. I'm Ross Sandler, and a professor at New York Law School. I've been following the cases about the appointment of U.S. attorneys, which have been successful. So I'm very curious about what you see as successful litigation strategies against Department of Justice policies beyond that. Do you have, I'm very curious about the litigation, actual strategies or theories that you might have.
Does anybody have thoughts about that? It's a great question, but kind of a hard one.
Mary, isn't your group called Washington Litigation Group? I feel like you're the expert on this.
Yeah. Well, no, I mean, it's a big, it's a really big question, Professor. I think any strategy has to be, and this is picking up a little bit on Sonia's point, unfortunately, because it's a bit pessimistic, but has to be a very long-term strategy. I was reminded recently by a very wise person, my mother. She asked me, do you know what year Plessy versus Ferguson was decided? Does anyone know?
1896.
And what year was Brown versus Board of Education decided?
1954.
It's a long time. So it is a long-term strategy that we have to pursue. But, I think, I'm trying to answer your question succinctly, and my mind is racing with all of the possibilities. But, I think what the U.S. attorney appointments points to is just, that's really a vindication of statutory interpretation, and sort of, how the codes actually can be very, very helpful in parsing some of these, or withstanding some of these assaults. Like, there are actually rules. They are arcane, but they are codified, and there's a way to discern how they should work. So I think, a strategy that sticks to the law and just the facts, ma'am, and that thinks about this in a really long-term sense and includes, at least one round of Supreme Court litigation in every attack is what we're going to be looking for.
Emily, can I push back on the pessimism?
Yes.
And I know, I don't mean to be too dismissive. I don't think it's helpful it cannot be the core part of our solution to parade this kind of litany of flaws of the legal profession that have occurred, particularly in problematic language. It's helpful to kind of look at it and say, there's an issue here, but this issue has occurred repeatedly through history, right? The 1200s had the Magna Carta. There were people pushing the king to sign it because of the lack of an independence of the prosecution, because the king was the law, right? Then there were cycles of recourse in response to that. Kings decided to take power back and use star chambers to whip people into shape with their power, and then people responded. They wanted an independent judiciary, right? There was a Bill of Rights in the 1680s, then there was the Settlement Act, right? And then our founders saw all of that and said, we want that independence enshrined in our founding documents. When they talk about King George, we read this in my family every year, the 4th of July. When they talk about that long train of usurpations and abuses, and there are words I still can't pronounce despite having to read them over and over every year, that King George encountered and inflicted upon the people of America, part of it was the independence, right? King George inflicted his will, made the judges bend. They talked about the Murder Act with folks who would take soldiers, British soldiers, and take them back to Britain to be punished there or leniently treated. Our country has, and human history, right, has faced these relapses. And so it's a relapse, but we've rebounded. And so, look, you want to talk specifics? Yes. I have met in a room with folks who were in charge of the negotiations coming out of South Africa to come out of apartheid. I have talked with the first person to establish the free press in Kosovo. I talked with the senior folks to lead the Arab Spring. There are people who are concerned, and so your concerns I get. We should call them out. To a T, every single one of them said, America is responding. They're concerned, but the country's responding. And so we have to keep responding. Don't drown in this litany of horribles that does exist. Remember that we've done this before and we can do this again.
That seems like a great note to end on. Thank you so much.
So let me thank our, this is really nothing. First of all, let me thank all of you for your public service and for being with us here tonight. And Emily, thank you for leading us through this discussion, as well as your fantastic journalism, and the article you wrote with Rachel should be required reading for everyone. But this is a conversation that will continue. And just to give you an example, I invite you all back to this room on next Monday night. You can think of it as part 2, but the City Bar is honoring Judge Michael Luttig, and will be presenting a program in his honor on the American Judiciary and the Rule of Law 2026. So that's another critical facet and angle on all of these issues. And I hope also that we can reconvene this group, all of you, and have a rousingly upbeat story to tell a year or two from now. But I do think we are going through the crucible, and we will come out the other side, and how we all act in this moment will be extremely important. Thank you all for joining us.